This podcast is brought to you by the School of Advanced Study, University of London.
Thank you very much, Patricia. And I'd also like to extend my gratitude and thanks to the Commonwealth Car Magistrates and Judges Association, of which I've been a member for several years, for inviting me to be a participant in this most interesting conference of one day. As Patricia says, this topic, the evolution of courts, can take several forms. It could go into the common law and the history of the common law, which I will base mine principally about, and address the question of the evolution of the English common law and courts within the Caribbean society. And it could also involve looking at the technology, today's technology, where courts are driven by what's more modern rather than archaic systems of running courts. But that is a different topic. I think, coming from the Caribbean, it may be more interesting to you to see and to learn how the English common law impacted on Caribbean societies. Now, I lead first of all with the advent of the English common law into the Caribbean. In the 17th and 18th centuries, Britain continued its quest for more lands to conquer and sought to extend its influence to the far-flung corners of the earth with the boast that the sun never set. As Britain expanded, she took to her colonies all of her institutions, social, financial, religious, and legal, inter alia, and established them along identical lines with those in the mother country. With regard to the legal system, the English common law became the common law of the particular colony, and the structure of the court system in large measure mirrored that of England, with no regard to relevance or suitability to local conditions. Some of the Caribbean islands and the mainland territory of Guyana, conquered by the British, were no exception. They inherited all of the institutions and the legal system of England. In some of the English-speaking territories of the Caribbean, certain aspects of the common law of England were expressly preserved as the law of the colony by legislation. In Guyana, for example, the Civil Law of Guyana Act was passed on the 1st of January 1917 to codify certain portions of Roman Dutch law and to substitute the English common law and principles. Section 3b provides as follows: the common law of Guyana shall be the common law of England as at the date aforesaid, including therewith the doctrines of equity as then administered or at any time hereafter administered by the courts of justice in England. And the High Court shall administer the doctrines of equity in the same manner as the High Court of Justice of England administers them at the date aforesaid or at any time hereafter, end of quote. This act was passed to codify certain portions of the Roman Dutch law which applied in Guyana in relation to immovable property, and which is still the case. The island of St. Lucia, in like manner, expressly provided for the common law of England to apply to certain aspects of the law of the then colony. And Article 917A of the Civil Code of St. Lucia is to this effect, and that is, subject to the provisions of this article, from and after the coming into operation of this article, the law of England for the time being relating to contracts, quasi-contracts, and torts shall mutatis mutandis extend to this colony. Now, the structure of the court system. The English court structure in most instances was transported in toto into the Caribbean territories without reference to relevance, cultural patterns, or size of the particular island or state. Provision was made for magistrates' courts, district courts, and high courts. All appeals from the high courts or supreme courts of the Caribbean territories went to the Judicial Committee of the Privy Council in England, and in most cases, this is still so. In the middle of this century, there was established an intermediary court of appeal with a varied nomenclature in the Caribbean. First of all, the West Indian Court of Appeal, then with an attempt at federation, the Federal Supreme Court, and lastly, the British Caribbean Court of Appeal. With the advent of independence, most of the states established their own courts of appeal, but retained the Judicial Committee of the Privy Council as their court of last resort, with the exception of Guyana, which abolished appeals to the Privy Council in 1970. Since the establishment of the Caribbean Court of Justice in April of 2005, 3 Caribbean countries have now accepted this court as their final courts of appeal. That is Guyana, Barbados, and Belize. There have been still and will continue to be arguments for and against the retention of the Privy Council as the final court of appeal of the Caribbean region and its substitution by a regional court, which I will discuss later. In some instances, certain states of the Caribbean have established special courts to meet special needs in the particular society. One example of this was the establishment of the gun court in Jamaica in the early 1970s to deal with the alarming rise in crimes involving the use of firearms. Family courts have also been established in some Caribbean territories to adjudicate on all matters pertaining to the family. Of course, there have been, for several years, in some territories, juvenile courts which were established to handle all matters affecting juveniles and were presided over by a magistrate who held the hearings of criminal offenses committed by juveniles in camera. Probation officers were utilized to carry out investigations of the juvenile's family background with a view to determining punishment, which invariably involved committal to a correctional and rehabilitation center. In Guyana, there was also established a land court with jurisdiction to adjudicate on petitions for declarations of title to land, having regard to the Roman Dutch system of conveyancing. In the colonial era, nearly, if not all, of the Caribbean colonies were presided over by English magistrates and judges, mainly with little or no knowledge of local customs and cultural traditions. They applied the English rules and laws rigidly and uncompromisingly, sometimes with ridiculous effects. For example, there is no provision in the laws of some states for deeming, in the laws of some states for deeming someone found wandering a rogue and vagabond and imposing a term of imprisonment when all that he may have been guilty of was not having a home or a family. The Caribbean courts during this period in our history also followed the rules of procedure of the English courts. The English rules of the Supreme Court formed the base upon which the rules of court of the colonies were founded. In most instances, these rules were taken verbatim from the English rules. However, in some instances, procedural rules were formulated to meet local conditions. For example, in Guyana, there are rules regulating the procedure for entering oppositions to the passing of conveyances for land, which is based on the Roman Dutch system and is peculiar to Guyana. Also peculiar to Guyana and some other Caribbean territories were the rules permitting barristers at law to act as solicitors prior to the fusion of the profession, which resulted in all legal practitioners being referred to as attorneys at law. This came into effect roughly in the early 70s. The conferment of silk on practitioners who satisfied the necessary criteria has been retained, with the title now being referred to as senior counsel. Now, I'll give some examples of judicial adaptation of the English common law to local situations. As in other areas of the law, the English matrimonial rules were applied inflexibly, with sometimes catastrophic results. There's a case of Henry and Henry, which was decided in 1959. which is a decision of the Supreme Court of Trinidad and Tobago in its appellate jurisdiction, is an example of the impact of the English common law on society in the Caribbean and the effects it can have on the lives of people. In that case, a wife lawfully married under the provisions of the Muslim Marriage and Divorce Registration Ordinance brought a complaint against her husband under the Separation and Maintenance Ordinance for maintenance on the grounds of his willful neglect to maintain her. The magistrate found the complaint proved and made an order. The husband appealed. At the hearing of the appeal, further evidence was received from an expert witness in Islamic law and custom, which established that Muslim marriages are potentially polygamous. It was held, one, that the only kind of marriage that entitled the parties thereto to the remedies, adjudication, and relief of the matrimonial law of England, upon which the Trinidad and Tobago general law relating to marriage is based, is a marriage that is monogamous to the Christian sense, in the Christian sense of the term. And two, that a Muslim marriage not being monogamous in the Christian sense of the term, the magistrate had no jurisdiction to make an order for maintenance in this case. A learned Chief Justice in the course of a judgment made this comment by saying, it's a well-established principle of law that the only kind of marriage that entitled the parties thereto to the remedies, adjudication, or relief of the matrimonial law of England, which is the basis of our general law relating to marriage, is a marriage that is monogamous in the Christian sense of the term. He went on to refer to the oft-quoted dicta of Lord Penzance in the case of Hyde and Hyde, to the effect that marriage, as understood in Christendom, was defined as the voluntary union for life of one man and one woman to the exclusion of all others. The decision turned mainly on the wording of the Muslim Marriage and Divorce Registration Ordinance, which provided for the registration of Muslim marriages and divorces, but did not stipulate, unlike the Hindu Marriage Ordinance, that a marriage solemnized between persons professing the Muslim faith shall be valid as if it had been solemnized in conformity with the provisions of the Marriage Ordinance, which related to marriages between persons of the Christian religion. It must have seemed incredible to nationals of a country whose marriage had been registered in accordance with the law to discover that that marriage was regarded as polygamous and not recognized because it did not conform with the Christian and English concept of marriage and was, in quotes, repugnant to local matrimonial law, a quotation of counsel for the appellant. In most of the Caribbean territories, English matrimonial law was applied, and the grounds for the dissolution of marriage were the same as those in England, with the exception of Guyana, where there exists the Roman Dutch concept of malicious desertion, which is desertion proceeding ex militia, that is, from design or premeditated determination. The ratio decidendi in the case of Sibs and Sibs indicates the influence of the concepts of English law on a Roman Dutch concept, when the Court of Appeal held that there was no difference in the state of mind required to found malicious desertion and that of the English doctrine of constructive desertion. A Court of Appeal judge in the course of his judgment made this comment, I quote, "For my part, I can find no difference between the state of mind required to found malicious desertion and that which must exist in the spouse whose conduct leads the other spouse to depart from the matrimonial home. The object is the same, the mode of achieving that object is different," end of quote. Guyana still remains the only country in the region which has retained this peculiar concept of malicious desertion, and is at present no more a nomenclature for the concept of desertion. In the very near future, it may fade into history, when the sole ground for dissolution of a marriage shall be its irretrievable breakdown based on a separation for a specified period. One can never overemphasize the urgency for the courts of our region to develop a jurisprudence of our own, modifying or expanding the common law to meet local conditions and the justice of a particular case. I shall expand on this a little towards the end of my presentation. The binding nature of the doctrine of precedent depends on the relative status of the courts concerned. Decisions of higher courts are binding on lower courts, and hitherto higher courts were also bound by their own decisions. Within the jurisdiction of the Caribbean, there are cases where our courts have departed from the doctrine of stare decisis. In 1964, the Court of Appeal of Jamaica did not consider itself bound by a decision of the former Court of Appeal. And the Court of Appeal of Guyana, in a criminal case, held that the principle underlying stare decisis in the Court of Appeal is not the same for criminal as for civil cases. And in criminal cases, it is less rigid. Jurisdiction of the court to overrule previously decided cases is a continuing one, and the court will exercise judicial review whenever there is to be determined some broad issue of justice, public policy, or questions of legal principle. In a criminal case or matter which is plainly wrong and manifestly unjust, the court will overrule it without hesitation. That same court, earlier in a civil case, held that it had jurisdiction to overrule former judgments of the British Caribbean Court of Appeal and to refuse to follow those of the Privy Council. More specifically, in the same year, in another case, the same court held that where the court has given a previous decision which it is satisfied was wrong, it is the court's duty to depart from that decision when it appears right to do so. These are just a few examples of courts not being rigidly bound by former precedents, which later courts found to be palpably wrong or unjust, owing only to the sake of stability and certainty. Evolutionary changes have taken place in several aspects of the law within the last quarter of a century. In the field of intestate succession, in most jurisdictions in the Caribbean region, children born out of wedlock can now share equally in the estate of a deceased father with children born within wedlock. The distinction between legitimate and illegitimate children has been removed, and the word bastard has been expunged from the statute books. This is indeed a major change from the accepted earlier position that when a child born out of wedlock was regarded as less than normal and was discriminated against in every sphere of life. Society's approach to such children has undergone a metamorphosis in the same way as society's acceptance of single motherhood. An example of progressive trends in leaving the law behind is the archaic provision of a wife pledging her husband's credit for necessaries. This was on the statute books in the Caribbean, I'm sure long after it had faded into history in England. This is an anachronism of the distant past, when wives had no independent means and were completely dependent on their husbands for financial support. Even though never utilized and abolished in most jurisdictions, the provision remains in the statute books in some, in others. The same can be said for the ludicrous claim for damages from a correspondent or adulterer. Fortunately, nearly all jurisdictions have revoked these anachronistic laws in the light of the changing and progressive attitudes of the modern world. In the Caribbean, our courts have not been oblivious to the winds of change blowing through our communities, and commendably have been swift to adapt and adjust to them. In the case of R.V. Hines and King, which is an interesting case, the Court of Appeal of Jamaica held that the trial judge erred when he refused to permit the defendant, who was a Rastafarian, to take an oath in a form which he declared to be binding on his conscience, but which did not conform with the prescribed Christian oath laid down by statute. By so doing, the trial judge had deprived the defendant of his right to give sworn testimony in his defense, and his conviction, therefore, could not stand. Oaths taken by witnesses throughout the history of the English common law followed prescribed forms in conformity with Christian principles, and one of the learned justices expressed the view that however misguided one may think the defendant to be in his professed belief as a member of the Rastafarian sect that the Emperor of Ethiopia is a divine being, the fact remains that such is his professed belief, and the form in which he wished to take the oath was consistent with that belief and declared by him to be binding on his conscience. In a criminal case, the Guyana Court of Appeal expressed the view that although for obvious reasons it will be predisposed to accept and normally will accept the judgment of the House of Lords on a point of English common law as being correct and as our law, it has jurisdictional freedom and a constitutional duty, judicial duty, to hold differently if the court is convinced fully on just grounds that the principle of rule laid down in it, or the declaration of what is not the common law, is misconceived and wrong. Within recent years, there has been a more liberal and pragmatic approach to interpretation of the law. And in England, there have been revolutionary changes in civil procedure. All of the old rules to which some of the former colonies in the Caribbean still cling tenaciously and hold sacrosanct have been relegated to the dung heap of history. The trend seems to be towards making courts more accessible to ordinary citizens and also ensuring a speedier and simpler resolution of disputes. Judicial personnel now look at fairness and achieving justice rather than enforcing strict compliance with rules. The Caribbean has followed suit, and the rules of procedure in the majority of jurisdictions have been updated and reformulated. Opinions have been expressed that courts of the Commonwealth must feel free to develop and interpret common law principles as they seem fit, having regard to local conditions and whether they consider particular decisions of the English courts wrongly decided, without being obliged to follow them because of statutory compulsion or to preserve judicial uniformity. I now pass on to deal with abolition of the appeals to the Judicial Committee of the Privy Council and the establishment of the Caribbean Court of Appeal. It is opposite at this point to consider the desirability of developing a jurisprudence peculiar to our needs, culture, traditions, and regional objectives. Inextricably tied to this laudable goal is the compulsion to establish our own final court of appeal. We have taken our own political, economic, and social destinies into our own hands with the assumption of independent status in all but one of two of the Caribbean islands and the establishment of the Commonwealth Caribbean Community, CARICOM. Yet we cling tenaciously to a court thousands of miles away, established in colonial times to consider and determine appeals from its colonies. Several of England's former colonies have severed the umbilical cord and established final courts of their own. But we in the Caribbean, along with one or two other small Commonwealth territories, seem reluctant to leave the nest and fly with our own wings. Happily, in April of 2005, the Caribbean Court of Justice was inaugurated with two jurisdictions, original and appellate. All of the member states of the English-speaking Caribbean, together with Suriname and Haiti, have acceded to the original jurisdiction, having empowered the court to apply and interpret the provisions of the Economic Treaty, which is the revised Treaty of Chaguaramas, to which Suriname and Haiti are also members. However, only 3 states have so far acceded to the appellate jurisdiction: Barbados, Guyana, and Belize. In its original jurisdiction, the court has power to interpret the revised Treaty of Chaguaramas. Hence, to date, we find that private citizens and companies who wish to sue a particular state can do so by coming to the court in its original jurisdiction. The court is still in its infancy, being just 9 years old, but the appointments procedure for the recruitment of judges has received commendation internationally. The appointments are made by an independent regional judicial and legal service commission comprising representatives of the regional bar associations, regional public service commissions, regional universities, and civil society. The governments of the region have no control over the appointments, and judges sit on the court in their personal capacities and not as representatives of the country of birth. They are appointed if they satisfy the required criteria and are drawn from common law as well as civil law jurisdictions if proficient in international law. Only the appointment of the president of the court requires the formal approval of the states upon a recommendation of the Commission. The time has come for the peoples of the Caribbean region to take control of the administration of justice, as has been the case in relation to other aspects of regional responsibility. This fact was highlighted by the Privy Council in a case of John and others against the Director of Public Prosecutions for Dominica, when it held inter alia that questions of the evaluation of evidence are essentially matters for a local appellate court and are not matters upon which, generally speaking, the Judicial Committee of the Privy Council would presume to differ from that court, whatever views their lordships might have been disposed to take had the appeal in question initially come before them. Whatever the shortcomings and deficiencies of the common law, it was an invaluable legacy inherited by Britain's former colonies and has been a unifying force among countries that share the same legal system. Its influence may be slowly waning, even in a motherland that gave it birth, as time and again it has yielded to statute which threatens to obliterate it completely. English law is fast becoming codified as the legislature seeks the medium of a statute to correct defects which surface in the common law and to provide remedies where none existed before. The influence of Britain on our former colonies is strong, and despite their independent status, many countries of the Commonwealth very often follow verbatim the wording of English statutes in drafting their own. In spite of, and maybe because of the varied mosaic of cultures, traditions, and customs of the countries which share the same history of English colonialism, the common law and the body of precedent built up around it has been enriched in its development and made strong and dynamic. May it always remain so, even in a world which is changing rapidly and moving inexorably forward. Thank you.